My name is Bruce Oakes, and I'm one of the partners with the law firm of Oakes & Fosher. Oakes & Fosher dedicates its entire legal practice to representing individuals nationwide who have had an issue with their stockbroker or stock brokerage firm in the handling of their investments. So what happens when an individual has a problem or complaint with a stockbroker? Actually, a lot of people don't know that there is any recourse. People view doctors and lawyers as types of professionals that are held to high standards, but stockbrokers and investment advisors are also held to those high standards. And if there's an issue with a stockbroker, if a stockbroker violates a duty or is negligent or defrauds an investor can take legal action. Now, this legal action is done through arbitration. It's not done in a courtroom. The forum that's used for these arbitrations is provided by FINRA, which is an acronym for the Financial Industry Regulatory Authority. The reason that all these cases are brought in arbitration is that the stock brokerage firms, when they have clients open accounts, they have you sign an agreement that says any disputes will be brought through the arbitration process rather than in a courtroom. Now, this is not a bad thing for the investor. It actually makes it easier to collect. It makes it an easier process in discovery, and the time it takes from the beginning to the end is shorter than being in the courtroom. Take those three things one at a time. When I say that it makes it easier to collect, it's because if you do bring an arbitration against a FINRA licensed broker and you win, the brokerage firm has 30 days to pay the award. And if they don't pay the award within 30 days, they are suspended from membership. So if you win your case, the brokerage firm will, in almost all instances, pay the award within 30 days in order for them to keep being able to keep doing business. You don't have to get a judgment or you don't have to have a garnishment, you don't have to take any of those steps. Now, the second item that makes arbitration a little bit easier than the court process is discovery. Discovery is the process of providing documents and information to the parties in the litigation. Now, in a normal courtroom procedure, there's going to be depositions. In arbitration, there are very rarely any instances where there will be depositions. The third item I brought up was the time period. Usually arbitrations take somewhere between 1 year to 18 months. Sometimes they'll go a little further. They can take 2 years to completion. There are very rarely appeals. In fact, the only instance that you can really appeal for is for bias by the arbitrators or some type of manifest disregard of the law. But only, I'd say, typically maybe 2 to 5% of all awards end up being appealed. And of those, it's very difficult to win an appeal for a brokerage firm when they lose an arbitration. So the arbitration process, although mandated by brokerage firms, actually does benefit the individual and makes it a little easier to bring their complaint. Oakes & Fosher has been in business for the last 15 years assisting investors through this process. We've handled cases for probably close to 1,000 investors. A lot of these cases end up being settled, but some cases are tried, and Oakes & Fosher has tried close to 100 FINRA arbitrations to completion, and we've recovered in the majority of those cases. If you or someone you know has had a problem with a broker or brokerage firm, please contact us, and we'll see if we can be of any assistance to you.